Welcome to This Explainer. Today we are unpacking an 8-page administrative law decision that honestly perfectly captures the highly relatable and, let's be real, sometimes completely maddening drama of neighborhood HOA disputes. If you've ever lived in a planned community or even just daydreamed about taking on a backyard DIY project, well, this one is absolutely for you. Let's jump right in. So, what really happens when you decide to build on your own land without, asking the neighbors or double-checking that community rulebook? We're looking at a fascinating, kind of wild legal case out of Arizona. It's the Pecos Ranch Community Association versus Randy and Sharon Hoyum. Through this story, we'll see exactly what goes down when a backyard home improvement project collides head-on with community rules, city codes, and the very heavy hand of administrative law. Section 1. The unapproved backyard shed. Okay, so this all kicked off in late 2009. And the timeline here, it escalated incredibly fast. It's practically a masterclass in how quickly things can go sideways. The Hoyums start building this freestanding structure in their backyard in November. By December 1st, they get what's called a friendly reminder letter from the HOA. You know the type. It basically said, hey, remove this, it's visible over the fence line and unapproved. 3 days later, on December 4th, the Hoyums scramble and submit an architectural review form asking for permission. But on that exact same day, the City of Chandler swoops in with a stop work order. Less than a week after that, on December 10th, the HOA officially denies the request. So in literally just 2 weeks, the walls had completely closed in on this whole project. And this rapid escalation didn't just stop at a few warning letters. Because the Hoyums were building without zoning or building department approval, the situation bypassed the neighborhood gossip and went straight to the Chandler Municipal Court. By December 2010, a judgment was entered against Mr. Hoyum for a uniform building code violation. The immediate results? A $320 fine. But as we're going to see, that financial penalty was really just the tip of the iceberg. Which brings us to Section 2. HOA rules and city codes. Right, so to understand how a simple backyard shed caused such a massive legal headache, we have to look at the foundational rules of this homeowners association. The Pecos Ranch community was governed by strict CC&Rs. That's covenants, conditions, and restrictions. Think of this as the absolute constitution of a planned neighborhood. The crucial point here is a specific clause stating that no building, fence, or structure of any kind can be commenced, erected, or altered unless, and this is key, until the Design Review Committee has reviewed and approved the plans. By moving into the community, the homeowners legally bound themselves to this specific requirement for prior approval. No exceptions. So let's look at the discrepancy between what was actually allowed versus what was built. It's pretty massive. The HOA guidelines, which were informed by the city, defined a storage shed as having a maximum roof area of 120 square feet. And it couldn't peek over the rear yard solid fence by more than 18 inches. The Hoyums, on the other hand, they built a structure that was 10 feet wide by 24 feet long. That is 240 square feet, literally double the allowed size. Plus, the property only had a yard depth of 23.5 feet, but city codes actually require a 20-foot setback. The structure was simply way too large, too tall, and way too close to the property wall. Moving on to Section 3, the bureaucratic catch-22. Now, this is where the story shifts from a simple rule violation into an absolute administrative nightmare. Because the shed was oversized and encroached on those setback limits we just talked about, the City of Chandler told Mr. Hoyum he needed to apply for a variance, an official exception to the rules. But here is the catch-22, and it's a doozy. The city refused to accept his variance application unless he first had the HOA's approval. Meanwhile, the HOA officially denied his architectural request specifically because the structure did not meet city building codes. Talk about a headache. He was completely trapped. He couldn't get the city permit without the HOA, and he couldn't get the HOA approval without the city permit. A perfect, impossible bureaucratic circle. Let's look at Section 4, the homeowner's defense strategy. Faced with this totally impossible situation and squaring off against the HOA, Mr. Hoyum took his case to an administrative law judge in November 2012. He represented himself at the hearing, and you can just feel the deep, palpable frustration he had with the HOA board. According to the hearing records, he actually accused the board of being, quote, an exclusive group of longtime retired friends, miffed because a homeowner would build something without their approval. He testified that he felt targeted, explicitly stating he felt picked on because his home was located in what he considered to be the, poor area of the community. And to back up his claim that the board was just acting arbitrarily, he brought receipts.
He submitted a ton of photographs into evidence depicting all sorts of other structures in the Pecos Ranch community. He's pointing out additional rooms with protruding skylights, glass-enclosed sunrooms, gazebos, tents, even artificial turf and front yard frog statues. His argument was basically, why am I being penalized for a storage shed when all these other neighbors are seemingly violating the aesthetic rules or getting special permission? It's a fair question, right?
Well, this brilliantly illustrates a really common misunderstanding in property law. The judge looked at all those photos of sunrooms and frog statues and determined that they were, legally speaking, entirely irrelevant. Yep, totally irrelevant. The ruling was stark. Whether other homeowners within the community had violated the CC&Rs was just not a valid defense for the Hoyums. The only issue that mattered to the court was whether the Hoyums themselves had violated the specific rules they agreed to when they bought the house. Pointing fingers at the neighbor's frog statues, unfortunately, doesn't erase your own contract breach.
And that brings us to Section 5, the judge's final decision.
So how exactly does an administrative law judge untangle a mess like this? It all comes down to the burden of proof. In these types of administrative hearings, the legal standard used is called a preponderance of the evidence. That's just a fancy way of saying one side's evidence is of greater weight, or more convincing, showing that their claim is more probable than not. The judge concluded that Pecos Ranch easily met this burden. I mean, there's absolutely no dispute that the 10 by 24-foot structure was actually built, and zero dispute that it was built without the mandatory prior approval from the Design Review Committee.
Which brings us to the judge's final recommended orders. These were officially certified as the final administrative decision by the Department of Fire, Building, and Life Safety in late December 2012. It broke down like this. First, within 60 days, the Hoyums were ordered to reimburse the HOA's $550 filing fee. Second, and this is the much more daunting part, they were given 90 days to either obtain that seemingly impossible Design Review Committee approval or alter, move, or completely tear down the structure to come into compliance.
So what should we take away from all this? This explainer really serves as a stark cautionary tale. In planned communities, that rulebook you signed, it literally dictates the reality of your property rights. A fun weekend DIY project can so quickly transform into years of fines, endless bureaucratic loops, and stressful courtroom hearings. So before you pour that concrete or order that lumber, you really have to ask yourself, are your own backyard plans legally bulletproof, or are you just one friendly reminder away from a massive stop work order? Thanks so much for learning with us today, and we'll catch you on the next explainer.